Good morning. I'd like to obviously welcome all of you and also to very warmly welcome our remote audience. And a word to our remote audience, you are certainly welcome to also, during the course of the question and answer, submit questions. If we can work them in, we'd obviously be delighted to do so, because the remote audience is obviously very important to us also. As the Dean mentioned, we are truly fortunate today to have an extraordinary lineup of true experts in this field of the legal and ethical dilemmas of technological warfare. And I think from an audience's perspective, our ability to bring such an extraordinary team here, a lineup today, I think will enormously educate the public. And I'm very much looking forward both to discussion amongst the panelists, but also to the questions and answers. And frankly, to follow up on what the Dean mentioned, I can think of few issues that are more contentious, complicated, complex than this question of drone warfare. And to that extent, I very much look forward to a spirited and engaged discussion amongst the panelists. To that end, the day is divided into 5 segments. We'll kick off with a keynote speech by Trevor Morrison, which I'll explain in a second. There will be 3 panels moderated by my colleagues Tony Ongi and Wayne McCormick. Have breaks in the middle, lunch in the middle, and then at the end, as the Dean mentioned, the unique aspect of the day is indeed this roundtable where the participants and I will engage in a discussion addressing hypotheticals with respect to the limits of drone warfare from the perspective of the law and ethical questions. A conference like this doesn't just happen overnight. Truth is, we've been planning this for approximately a year. It was born out of a conversation or a series of conversations. We asked ourselves, what's going to be, looking forward a year later, what's going to be a hot button issue? I think it's fair to state that we got it right. Whether fortunate or unfortunate is an open question, but I think we on this one we got it right, and to that extent there are a number of people who were deeply involved in making today happen, and I want to thank them. First of all, the law review. Clark Hollings, you did an extraordinary job of working with me, with the Dean, with Professor McCormick, Professor Ongi, and all the panels to make this happen. Warm congratulations to you and your whole team. The Dean mentioned the events team here at the law school is just extraordinary. The IT team, I don't know if Mark is here, the IT team, you guys are the best. You'll see we're going to have, one of our speakers is going to be in Canada. We're going to have him, he's fed in from Canada, thanks to the team. And the PR team, Barry and Dana, without all of you, today doesn't happen. And my heartfelt thank you to all of you. Our keynote speaker, my very good friend, Trevor Morrison. First of all, welcome to Salt Lake City, Trevor. Trevor is the Liviu Labresco Professor of Law at Columbia Law School, where he's also the faculty co-director of the Center for Constitutional Governance and the faculty co-chair of the Herzog Program on Law and National Security. He teaches and writes about constitutional law, federal courts, and national security. Prior to joining the Columbia faculty, he was at Cornell. He has clerked in the Court of Appeals, also the Supreme Court. He was served as solicitor in the Office of Legal Counsel of the White House. I think most importantly of all, there are few people who are more thoughtful, cogent, and incisive on these questions than Trevor. And to that extent, Trevor, it truly is a pleasure for us to have you with us today. Please.
There are times when, after receiving such a generous introduction as that, it seems the only place one could go is down, and so I'm tempted to leave it with the introduction. But I won't. Thanks so much for having me. I'm very pleased to be with you all here today. The legal and ethical limits of technological warfare. Well, that's an extremely interesting, timely, and important topic, or really, to my mind, set of topics, and I'm very glad that we've gathered to discuss them here today. Of course, there are many examples that each of us can think of how rapid technological developments are changing how warfare and warlike acts are conducted, and there are sure to be even more dramatic changes in the not-too-distant future. One example, of course, is the use of unmanned aerial vehicles or drones in lethal targeting operations, but that's not all. I think we can think also of current research and development efforts not yet in the field to deploy even more automated and autonomous weapons, robots, literally, where the human dimension in the deployment of the weapon is even less than with respect to drones. I think we could include also in this general topic hostile state-sponsored actions against a range of targets in cyberspace, and whether that should be thought of as war. Certainly it's a technologically sophisticated way of expressing hostility against one's adversaries. Developments like these raise a host of very difficult and pressing questions. What body or bodies of law apply to these developments? Is existing domestic and international law governing the use of military force applicable? Is it capable of being sensibly applied in these contexts? Should it be applied to these contexts? If the answer to those questions is no, what, if any, law should apply? Do we need new laws of some kind? Who or what should supply those new laws? And finally, within the government, who should even attempt to figure out these various questions? Well, rather than attempting to provide any comprehensive answer or set of answers to these and other questions here, something I really couldn't hope to do, in these remarks, I just want to identify a few general issues and considerations in the hope that in doing so, I can help frame some of our discussions for the balance of the day. I should note at the outset that I consider myself principally a scholar of domestic U.S. constitutional and public law, with an emphasis on questions of executive power. So although I spend a fair bit of time thinking about war powers-related questions, it's mainly from a domestic law perspective. That said, I mean these remarks here today to apply, at least analogically, not just to domestic legal questions and implications of the new technologies in war, but also to the international legal dimensions of these problems. Okay, to start. In very rough terms, I'll organize my remarks around some substantive issues first, and then what I'll call oversight and transparency issues second. Substantive. A dominant feature of much of the law affecting the use of military force is that it is based in substantial part on historical practice. Many of the sources of positive law, including the U.S. Constitution domestically, treaties like the Geneva Conventions internationally, are textually spare, and on a number of key issues, they use general terms that are anything but self-defining. Historical practice often fills the gap. Specifically, past actions by states at the international level and by presidents and Congresses domestically are often treated as evidence of what the law is on a particular question, indeed as partially, at least, constitutive of what the law is. So in U.S. constitutional law, the idea that historical practice might contribute to our understanding of certain key dimensions of the president's constitutional powers is often associated with Justice Frankfurter's concurring opinion in Youngstown, the famous steel seizure case from the Korean War era. As Frankfurter put it in a key passage, a systematic, unbroken executive practice, long pursued to the knowledge of Congress and not objected to by Congress, can provide a gloss on the Constitution's reference to executive power. That historical practice, in other words, can inform an understanding of the metes and bounds of executive power, including with respect to the president's power to direct the use of military force. Now, when it comes to questions of war powers, in the United States at least, we know that courts play little, if any, role. Justiciability limitations like the political question doctrine and standing severely limit judicial involvement in these issues, though not completely, as the Supreme Court's involvement in various war on terror issues during the Bush administration reveals. But instead of regular judicial review of the legality of certain potential or ongoing uses of force, something that we do see in other legal systems, I think especially of the much more active and regular involvement of the courts in these kinds of questions in Israel than in the United States. But instead of that kind of regular involvement here, these issues are taken up largely by lawyers within the executive branch, with some oversight sometimes by representatives in Congress. When these lawyers in the executive branch address these issues, they commonly look to historical practice. Some examples. The 2011 military operation in Libya, I think, is a prime example. As you know, in the spring of 2011, President Obama ordered the use of military force in Libya, virtually all of it aerial, where the Gaddafi regime was poised to create a massive humanitarian crisis by killing potentially tens of thousands of its own people, and in so doing to further destabilize the region in ways that President Obama claimed, at least, could threaten U.S. national security. So Obama ordered the operation in the absence of any authorization from Congress. And to establish the legality of his doing so, the administration relied on a written legal opinion by the Justice Department's Office of Legal Counsel, OLC for short. OLC's opinion acknowledged what is obvious, which is that the Constitution gives to Congress alone the power to declare war. But it also emphasized that there are many examples, especially over the last 30 to 40 years, of the president ordering the use of military force in relatively limited engagements, especially where one could say that boots on the ground are limited, without authorization from Congress. And OLC relied heavily on those episodes, those many past episodes, in which it claimed that Congress had effectively acquiesced to argue that the president had the authority to order the use of military force in Libya without advance congressional authorization. So that's a use of historical practice as an example. Another issue in the Libya operation arose as it continued into the summer of 2011, and in particular as it went past the 60-day mark. As you know, the War Powers Resolution, passed by Congress in the aftermath of the Vietnam War, attempts to sort of structure the use of military force, and in particular, its basic goal is to limit the extent to which the president can lawfully order the U.S. military into action unilaterally without Congress's advance authorization. A key provision of the War Powers Resolution is the so-called 60-day clock for hostilities that provides that if the president initiates hostilities without congressional authorization, that he either needs to get congressional authorization for those hostilities within 60 days, or they need to cease, or they at least need to cease being hostilities, that is, be drawn down to a level below whatever the threshold for hostilities is. According to press reports, at least, OLC thought that this operation constituted hostilities up to and well past the 60-day mark, so thought that there was a serious War Powers Resolution problem. Ultimately, press reports claim anyway, that the White House decided to go with a different view on this question, as espoused by State Department legal advisor Harold Koh, who thought that there was a sufficiently strong argument that the operation did not constitute hostilities. It just didn't rise to the level of hostilities, so there wasn't a 60-day clock problem under the War Powers Resolution. Now, that argument was met with a certain amount of incredulity in many quarters, especially given press reports that American warplanes had engaged in and were continuing to engage in dozens of strikes on Libyan targets, and that American-operated unmanned drones were engaging in dozens more strikes across Libya. But in defending the idea that these actions did not amount to hostilities, Koh relied on a definition of that term, hostilities, that had been proffered by a predecessor of his, State Department legal advisor in the Ford administration, and that Koh said the executive branch had relied upon ever since as a matter of executive practice. So here's historical practice entering again, not with the claim that Congress had acquiesced in this practice, but just with the claim that the executive branch had consistently followed a particular understanding of what hostilities meant. And on that definition, hostilities means only a situation in which units of the United States Armed Forces are actively engaged in exchanges of fire with opposing units of hostile forces. The argument, as for Libya, was that the standard wasn't met because the Libyans had no real capacity to fire back at US planes and drones, so there weren't any exchanges of fire, just lots of it from the United States. All right, my point here isn't to argue for or against the substance of Koh's argument on hostilities, nor to argue for or against OLC's earlier opinion on the president's constitutional authority to initiate the operation without congressional authorization. Instead, my point is to note that because these arguments relied substantially on past institutional practice, on historical practice, we need to ask questions about how that method of legal analysis should apply when technological change dramatically alters the war-making means at the president's disposal. So think about OLC's reasoning. The claim there was that this is not a war triggering the need for a congressional declaration of war or authorization because it was not, according to OLC, a prolonged and substantial military engagement involving exposure of US military personnel to significant risk over a substantial period. That's what it suggested a war amounted to, and less than that, historical practice, OLC said, suggested the president could initiate without congressional authorization. But here's the problem. What if technological change dramatically expands our military's capacity to inflict massive damage on an enemy without our military personnel ever being subject to significant risk? Should the same old standard as for the difference between a war requiring congressional authorization and operations that can be initiated by the president on his own, should the same standard apply? Or should we acknowledge that some effort of analytical translation needs to be made? And what about Coe's reasoning on hostilities? It's basically the same problem. No exchanges of fire in this operation, but our ability, especially through drones, to inflict massive harm with no or virtually no exchanges of fire with the enemy is vastly greater today than it was even in the Vietnam era. And so why is it clear that the same standard should apply? The factual outcome of this will be much greater war-making capacity, less regulated by law. And so it raises a question of what it means faithfully to apply a standard that's generated from practice to circumstances whose facts are dramatically different from the circumstances that produced that practice in the first place. Now, to be clear, I'm not arguing that technological advancement should render familiar legal principles and familiar modes of legal argument like reliance on historical practice totally irrelevant. I'm not arguing that. Nor am I necessarily arguing for any categorical prohibition of new ways of conducting war. Some have made those kinds of arguments. For example, some have argued that certain kinds of automated weaponry, either now in use or potentially soon in use, should be regarded as per se violative of the international law of war. They're talking to some extent here about drones, but also of these more fully autonomous and automated weapons that can potentially inflict massive damage precisely and with very little real-time human involvement. The argument against these weapons is that by removing human soldiers from risk and reducing harm to civilians through greater precision, the disincentive to resort to armed force is diminished. And the result then could be a greater propensity to use military force and to wage war because the downside risks of it are mitigated by the greater precision and greater sort of autonomy of these weapons. Well, I tend to agree with my colleague Matt Waxman and with his co-author Ken Anderson when they respond to these kinds of arguments by saying that precisely the same objection can be raised generally with respect to any technological development that either reduces risk to one's own forces or even more perversely reduces risk to civilians because it, this argument would suggest, invites more frequent recourse to force. But as Matt and Ken point out, we do not in general think that any marginal technological advance in weaponry's precision or lethality renders the existing law of war irrelevant, nor that this new advance needs to be prohibited categorically. I think they're right that we shouldn't take that view. For one thing, it would be fruitless. There's no way that law can prohibit the advance of technology in such a dramatic way. And it's not clear why we should think existing bodies of law are just irrelevant, because it's not clear what the alternative would be. Would that be that the law didn't regulate this at all? That's one possibility, right? Why does one assume that if we argue that existing bodies of law don't quite capture the present circumstance, that the result would be prohibition as opposed to no regulation whatsoever? So I think Matt and Ken are right that this doesn't seem to establish a categorical reason to reject these more technologically advanced kinds of weapons. But at the same time, I don't think that there's nothing to worry about here. It's too many negatives. I do think that there is something to worry about here. Many of the legal rules, international and domestic, governing the law of war and the use of military force are derived from the past use of such forces in contexts where significant military power, in order to be used, did expose our own personnel to some risk. And that risk imposed to some degree a kind of self-limiting quality on war and the use of military force. Technological advances that dramatically reduce the risk to our own military personnel while increasing our capacity to inflict damage very precisely, surely do undermine to at least some extent this self-limiting function. And they surely do alter the basic cost-benefit analysis of whether to undertake a given military operation or to pursue a particular target. I think we just need to recognize that fact. Now, is the answer total prohibition or total overhaul of our legal rules to the point of jettisoning decades or more of historical practice? I don't think so. But part of the answer should be greater acknowledgement that received rules need to be adapted to new circumstances, not applied mechanically as though there's no difference. It's more in the nature of analogy, thinking about underlying purpose of rules generated through practice than mechanical application. This is a sort of argument not for getting rid of historical practice, but for understanding the limited nature of the rules that historical practice are going to generate, and to understand that in moments of really dramatic historical change, a historical practice method of legal analysis is a little bit like trying to force a square peg into a round hole. What the lawyer needs to do is to understand that that's going to involve some whittling down of the hard edges of the square peg and maybe a little bit of expanding of the hole, not to abandon the effort altogether, but to understand what's happening here, and therefore to confront directly the choices that are entailed in the way the analogies are drawn from historically developed bodies of law to present circumstances. Okay, my second theme this morning is the importance of oversight and transparency, and I can be a little bit more brief here. As I've already mentioned, in the US at least, the involvement of the courts in the kinds of questions that we'll be thinking about today is extremely limited. And as I hope is already clear, technological warfare raises a host of very difficult legal questions. In addition to the ones that I've already noted, maybe the biggest challenge is what to think about the prospect of a potentially perpetual state of low-level war or warlike activity. This is enabled in a way that doesn't expose our own personnel to dramatic danger because of technological advances. Counterterrorism operations as involving the use of military force on a legal theory that's not geographically or even temporally bounded, and that might continue for the balance of our natural lives, describes a different relationship between states of war and peace than has traditionally been thought. So what should the law think about that state of affairs, and what should we think morally about that state of affairs? And what are its implications for how to think about the rule of law in a constitutional democracy? I think the implications are potentially quite profound, especially because the courts are, at this point anyway, unlikely to become involved. I think the government's response to these questions needs to include some greater transparency about how decisions are made, by whom, and according to what standards and legal theories. There are a number of reasons for this. A lot of the sort of actual use of the most technologically advanced weapons now at this government's disposal, and likely to be at it and other governments' disposal in the future, in their actual use and their actual deployment, are and need to remain classified. But that doesn't mean that the legal theories or that the decision-making processes about deciding in what general kinds of circumstances a certain kind of weapon or tactic could be used need to remain completely secret from the American people generally or from Congress. And there are reasons, there are even self-interested reasons for the executive branch to prefer some greater amount of disclosure. To the extent that some aspects of these sorts of operations needs to remain classified and secret, a trust can be built up in the executive branch's secret activities in this area if it's willing to disclose at least some of the basic ground rules or frameworks within which it's thinking about this. Of course, any one administration doesn't think of itself as likely prone to abuse of this kind of power, but it might think of its successors as more likely to be abusive with respect to these powers than it. So there's a way of putting in place a framework, even if it's not legislatively mandated, but if it's declared publicly in a way that it would become politically costly to abandon, as a way of guarding against abuse in the future. It's actually also a way, I think, of continuing to limit the role of the courts in this area. If the executive branch prefers to be able to make decisions about the use of military force with only the kind of limited judicial involvement, virtually non-existent judicial involvement we have today, then public disclosure of a rigorous process of legal as well as tactical and strategic analysis, I think kind of enhances the institutional credibility of the executive branch in a way that courts wouldn't feel compelled to intervene. You think in a slightly different context of the Supreme Court's habeas corpus decision in 2008 in Boumediene against Bush, where the court held that the constitutional privilege of habeas corpus extended to the detention of non-citizens at Guantanamo Bay. If there's one theme that comes through that opinion more than any other, it is that the court, by the middle of 2008, had simply lost faith in the ability or inclination of the executive branch to exercise power without judicial review in a responsible way in this era. That kind of argument doesn't have much doctrinal standing, but it's a kind of judicial mood that once a court adopts it becomes very hostile to the executive branch. And the executive branch tends to prefer for the courts not to become so intimately involved. A way to ward that off is actually to disclose more about the thinking and the frameworks governing the thinking within the executive branch, including especially with respect to the use of technologically advanced weapons. Why do I say including especially with respect to technologically advanced weapons? Because I think that even if we're more self-conscious and more careful about the challenges of translating historically developed principles derived from historical practice and applying them to the present, even if we're more careful and cautious about that, it is still likely to be the case that a whole lot of our best understanding of the law in these areas does not prohibit some of the most dramatic and sort of potentially consequential uses of these weapons. The human costs of these weapons are high, and it will be difficult for lawyers within the executive branch or elsewhere to say that they are categorically illegal. But the challenge for any responsible use of this kind of weaponry is to understand that just because something is legal doesn't mean that it needs to be exercised as much as it could possibly be. But just because there is legal permission doesn't mean that a government ought to take the action. The challenge then, picking up on the second aspect of the title of today's symposium, is to figure out ways for the executive branch to take seriously the ethical and moral questions that go into the use of technologically advanced weapons, as well as the legal questions. That, in my view, is very, very hard for the executive branch to impose on itself unilaterally. The pressures in the other direction are often overwhelming. That if the lawyer or lawyers are called in to examine the sort of governing legal principles that will apply in a particular context, are not prepared to say this is illegal, the idea that there ought to be sort of additional limitations imposed, even if there seem to be some strategic or tactical advantages in using the weapon in a particular context, is an argument that's very hard to get off the ground within the executive branch. One way to do it is to engage in a little bit of what, in a different context, Adrian Vermeule and Eric Posner have called executive self-binding. And that is to try and articulate in advance a set of ethical considerations that the executive branch will commit to thinking about and to identifying a process. This could happen through an executive order. It could happen more informally through a set of just speeches given by high-ranking officials within the executive branch, recognizing the importance of considering the ethical dimensions of these problems as well as the legal, and talking about a process that will be followed. That's difficult to do too, but in the absence of that having been done in advance, the idea that there can be a kind of moment to pause on the ethical dilemmas posed by the use of a particular weapon in the moment is even more fantastical. The risk that they will just be ignored and blown past is very, very high. And so there's a kind of like fundamental legitimacy that can be gained through the self-binding that can go on if the executive branch engages in enough of this sort of disclosure and transparency. It's not easy. But there are reasons to believe that actually this government right now understands the importance of this. One can point to a number of speeches over the last 2 years or so by people like John Brennan and Harold Koh, Jay Johnson, the just departed General Counsel of the Defense Department, Eric Holder, the Attorney General, and others, that seem more than anything else designed to describe to some maybe a too high level of generality, the decision-making process and the kinds of factors that are weighed in that process that's used to make determinations about using drones, say, in lethal strike operations. Koh, similarly, in the cyber context, gave a speech last fall, where he sort of confirmed the U.S. government's position that traditional principles of international law of war, govern in the cyber context. That sort of is a certain measure of disclosure on the legal front. I think you could have similar disclosure on the sort of ethical constraint front as well. The less courts are involved, and the less we know for sure what the substantive answers to these very difficult questions ought to be. That is, the more we understand the actual correct substantive answer is very hard to identify. The more we want to have a kind of procedural confidence in the integrity of the decision-making process in the government, and the more we should want to think that the government is thinking not just about legality, but about morality. I think there's no prospect of gaining confidence in that unless the government can find some way to commit in advance to a decision-making framework that builds in those considerations. So that's what I hope happens, and in my optimistic moments, I allow myself to believe that that might even be happening today. Those are my remarks. I look forward to the rest of the day. Thanks very much.